Hi, I'm Greg Dell with Dell Disability Lawyers. I'm here with attorney Cesar Gavidia, and today we're going to discuss a common question/issue that we see a lot. And the issue is, how do you deal with severance and a short or long-term disability claim at the same time? And what I mean by that is, how can you get a severance from your employer but not potentially jeopardize your long-term disability benefits because you're either being terminated or entering an agreement to leave? So let's get into, Cesar, first of all, like some of the issues that come up. Why is this even an issue in the first place, and how do you usually see it develop?
Well, it's very common because you see people who are forced to go out on disability. Sometimes in a particular circumstance, the medical conditions keeping them out of work for longer than maybe they ever expected to be out of work. Or maybe they could never go back, or the doctors haven't released them to go back. And they're facing a situation now where they're going to rely on these disability benefits for a prolonged period of time, and the employer can't necessarily just hold their position for them any longer. So there's a few things that can happen. An employer can terminate the employee, basically once the medical leave period, the family medical leave period is over.
Which is what, about 12 weeks?
About 12 weeks. There may not be any legal basis to, there may not be necessarily a violation of the law for the employer to terminate the employee, and they may need to just let them go at that point. And that can happen. In other cases, they offer them a severance or a separation from the company, and they offer them a sum of money. But in return for that sum of money, they're going to ask them that they release and waive many, many different potential legal causes of action against them. And sometimes unknowingly, people also release a disability insurer from having any further liability for a disability claim, even if they're paying them. So they could be paying them, or they could be going through a review. And if at some point that insurance company denies them or terminates the benefits, they may not have any legal cause of action to go back after that insurance company if they've signed a severance agreement with, the potential language.
Right. It's very dangerous, and often it's inadvertent that an employee, because here's what happens, is the employee's in a situation, usually they've been out of work for 90 days or or maybe 180 days, depending upon what's going on, and the employer is like, well, maybe we could just terminate you, but we don't want to have any issues, so we're going to offer you some money. And we're going to offer you a package of, maybe there's benefits also, whatever it may be. But in order to do that, we're going to give you this agreement. And these agreements have standard language in them, usually, that say, you waive any and all rights against us and any other affiliated parties and anything governed by ERISA. And that ERISA is really a buzzword. And sometimes they'll say, and any and all disability claims. But it may not say disability claims, which doesn't raise the flag for a claimant. But when they say any and all ERISA claims or any and all third parties that may be affiliated with us, that could include your short-term or long-term disability insurance carrier, and that's where the problem lays. But claimants at that point, or employees at that time, are told, usually in these agreements, you should be consulting with someone else to advise you on this. But they're also in a position where they're like, they need the money. They haven't been paid. The employer's offering them what usually equates to whatever, a couple weeks, a couple months of pay, and the claimant in that position, who's first of all not doing well, psychologically or physically due to a disability usually, and second of all, they have no income coming in. So they're like, yeah, I need the money. I signed the document, and they forget about it. So where does it resurface its ugly head, and where have you seen this, and how do courts look at this?
Well, very recently, a decision came out of the United States District Court of New York, Southern District of New York, and the case involved a territorial sales representative for a dental supply company, Kristen Schuler, and in that case, she had had a pretty significant fall. She suffered a traumatic brain injury. She was hospitalized for a few days. She returned back to work for some period of time, but continued having problems, cognitive problems, memory problems, concentration issues. And some years later, these problems didn't improve. She sought all forms of different therapies, And eventually her doctor said, and supported that she couldn't go back, return back to work as a sales representative. She went on medical leave, informed her employer she had to go on medical leave. The doctor signed all the necessary forms for her to go on medical leave. She submitted a disability claim to the disability insurer that the employer had, which was Sunlife Assurance Company of Canada, Sunlife. And Sunlife denied the claim. They said, the information you submitted is not really supportive of total disability claim. We don't see it here.
And that's highly unusual that Sunlife denied.
Yeah.
No,
Yeah,
not really.
no, it's not. It's not.
Kidding.
It's not really. But you consider, I was, in certain circumstances, years of medical treatment, years of therapies, probably neuropsychological documentation and reports and evidence, and you say, how could they deny a claim like this? But they did. They probably questioned, how was she able to work for as long as she was working?
Right. So she got punished for a good deed of trying to go back
trying
to
to
work.
push through, right, and do the best she could. And obviously the best she could just wasn't good enough.
So at some point, this woman, who wasn't our client, this is a reported case, and we always talk about disability cases around the country to keep in touch with what's going on and to educate the people who watch our videos, our clients, and ourselves to know what the latest case law is. At some point, I'm assuming she signed a severance agreement with her employer.
Well, she did. While this whole denial with Sunlife was occurring, her employer also approached her, probably telling her, listen, we have to unfortunately part ways, and we're offering you a separation package. There was all sorts of terms, all the terms we just discussed about releasing the employer from any and all causes of action, and there was language in there including ERISA actions. Now, during that time, she was appealing the decision with Sunlife. She hired a disability lawyer, not us. She had another disability lawyer to do the appeal, and the appeal was unsuccessful. And she accepted the severance package with the employer at that time. She also had that disability attorney review the severance agreement to ensure that she wasn't compromising or jeopardizing her LTD benefits or her short-term disability benefits and all of that. So ultimately, it was appealed, like I said, denied. They filed suit, and one of the first defenses, or the first things that Sunlife tried to do, was seek a dismissal on the grounds that she had released Sunlife from essentially any liability through the release or severance agreement that she signed with the employer. And the court actually laid out, its analysis of this whole situation. It basically came down to whether she knowingly and voluntarily released her rights to pursue her LTD benefits in this ERISA action. Interestingly, she'd even had communications with her human resources department at work saying, listen, by accepting this severance agreement, I want to make sure I'm not compromising my ability to appeal this decision with Sunlife. I want to make sure that everything is okay there. That was all part of that case. It's part of what the court reviewed.
And her employer had told her it was okay?
Her employer said it's fine. This isn't affecting your ability to appeal the decision. It was interesting how they worded it that way. This is what the case is reporting. This is what the court reported in their order. And the court went through this analysis. First, they needed to determine, in order to determine whether she had knowingly and voluntarily given up her rights to pursue her LTD benefits, is her level of education and work experience. She had a bachelor's degree, an MBA. She had extensive work experience with, as a sales representative, reviewing contracts and things like that. They found her to be a sophisticated individual. They found that she had the representation of counsel through this, which actually the severance agreement had advised her to get. She negotiated the severance agreement. So, they started at a particular, offer, and she negotiated a greater offer. And so they went through these various steps. Now, Sunlife was never specifically named or identified in that severance agreement. This is really important because one would think, well, if they're not identified in there, if they're not named as a specific party, then they're not released. Well, the court acknowledged that, look, yeah, they're not named in there. But when you released any and all ERISA, even ERISA causes of action against any entities or related affiliated parties, that also included the plan administrator, Sunlife, for this LTD plan. So unfortunately, what probably could have avoided this situation for her, and what we always advise our clients,
we'll talk about the solution here.
right,
Yeah.
is the specific carve out. And that's really, really important, because if that carve out was in there, and there was a carve out that would acknowledge that Sunlife is not being released, and that this severance agreement, separation agreement, is not affecting any LTD benefits or causes of action to pursue long-term disability benefits or short-term disability benefits against any potential plan administrator or entity, she probably would have been fine.
Yeah, absolutely.
Yeah.
And now that other lawyer is facing, it's likely, unfortunately, a malpractice action, which is terrible for that lawyer. But even worse is now this claimant, who's got these significant injuries and disability,
Right.
has no disability policy
Well,
anymore.
the wild part about this, right, is one of the other steps that the court looked at was looking at how much she was receiving through this severance agreement, which was around $25,000, versus the value of her long-term disability claim. The value of the long-term disability claim was over $1.5 million. Okay, so for $25,000, she just potentially gave up over $1.5 million. And the court said, well, you knowingly and voluntarily, released them.
Right.
So.
And we see this situation come up. Now, this happened after she was out and she had already been in appeal with Sunlife. But we see this a lot before, too, because there's a lot of employees who are at work, they know they're suffering, and they're not going to be able to continue working. And the employers and the employee know that. And they've been working together for years, and the employer wants to do the right thing and show their appreciation for their employee and also avoid any future issues.
Yeah.
So prior to even leaving, prior to even filing a disability claim, many, many employees get a severance agreement, even though they're arguably disabled at that point in time. And then guess what they do? Then they try to file for disability. Now, of course, you have to be disabled before the date of your final working,
Right.
Otherwise your benefits would end. But you can, and we help clients all the time, claimants, to deal with this while we're helping them to apply for disability, to again craft the language in your severance agreement so that you don't waive your claim in the future to long-term disability. And that's a lot where we see it in that planning stage, and we see a lot of people who, while they were still employed, they signed this severance agreement, which is really bad. And candidly, for the employers, usually they're not self-funded plans. It's an insurance company policy that the premium's already been paid. There's no exposure, no financial cost or anything usually to an employer to say, okay, we're excluding specifically any and all claims you have against that disability insurance company, because it costs the employer nothing.
Nothing.
So what's the risk? And any employer who doesn't want to do that, you're more often not better to say, keep your severance. I want my disability claim, because in this case, $25,000, you gave up $1.5 million in benefits. Makes no sense. But there's a lot at stake. This claimant had a lawyer who didn't know what he was doing. Not that unusual, but it happens. And it's a sad case, but it's a learning experience. And luckily, we can convey this message to other people, because people call us all the time to help them file for disability, and they're almost always presented with the severance. So if you're someone out there who has a long-term disability insurance claim, feel free to contact Cesar or myself. No matter where you live in the country, we're always available to assist you, and we'll always provide you with an immediate free phone consultation. Thank you.